represented to come before the court this morning is State of Ohio versus Daniel Austin. The state has waived oral argument. You have 15 minutes with which to present oral argument. We've read the briefs. We're seeking you, our counsel.
Thank you, Your Honor. Attorney Barbara Rogaszewski on behalf of Daniel Austin. Thank you very much. As you know, you've already read the briefs, so you know what Mr. Austin was convicted of and how many counts. And you know that we filed a brief containing 7 assignments of error. The assignment that I want to focus on for purposes of today's argument is assignment number 2, and that involving the polygraph testimony that was presented in the trial. As this court knows, polygraph testimony is generally inadmissible. In fact, neither the state nor the defendant can present, without a stipulation, any evidence with regard to a defendant's willingness or unwillingness to take a polygraph or the results of a polygraph examination. Courts have routinely found that that type of testimony is unfairly prejudicial. Even this particular court, when a defendant has testified as to their willingness to take a polygraph, this court has made a finding that is unfairly prejudicial to the state. In fact, the reason that we don't allow that type of testimony is because of the highly charged nature of polygraphs in general. It creates in the minds of a juror a value that has never been truly established in a court of law as to its probative value toward guilt or innocence. In fact, polygraphs are routinely called, both by laypersons as well as courts, lie detector tests. Even some of the courts that I cited in our brief specifically referred to a polygraph as a lie detector test. Of course, we all know, not being scientists, but being a part of the justice system, that there's no such thing as a lie detector test. What a polygraph does is it measures the autonomic nervous system responses to particular questions, whether a person's respiration changes, perspiration, etc., to determine if they may be deceptive in their answer. But persons like to hear whether we can tie up in a bow and present on a silver platter whether somebody's lying in court or has lied in the past, because it makes the findings so much easier.
But this case wasn't about that. This evidence wasn't about polygraph results, per se.
It was not. In fact, there was no testimony that Mr. Austin was ever offered a polygraph, took a polygraph, or any polygraph results.
Nor should there have been, correct?
Absolutely, it would have been inadmissible. As would be this testimony as to whether he would have been willing to take a polygraph. What's interesting about this is, and I didn't find any case law that presented this particular scenario, but in this case, as you know, Mr. Austin's half-brother testified, and this was the sole purpose of his testimony, that Mr. Austin had asked him to take a polygraph examination, posing as Mr. Austin, and that evidence was presented as evidence of consciousness of guilt. The problem with that is this, and this is an issue that was presented in State v. Montrum that we cited in our brief. We first have to address the issue that if Mr. Austin, if we find that testimony to be accurate or true, if Mr. Austin had in fact asked somebody to take a polygraph for him, that meant he was not willing to take it himself. And in State v. Montrum, they outline specifically why this testimony is such an issue. Because a refusal or an unwillingness to take a polygraph exam then leads to the belief in consciousness of guilt of the jurors, and then to guilt. And this inference is quickly and erroneously potentially drawn as a result of that. Now, the state never presented their presentation of this evidence as a refusal to take or an unwillingness to take a polygraph exam issue. They skipped straight to consciousness of guilt. But in fact, if Mr. Austin was seeking to have somebody take it for him, whether he was or he wasn't, and there was certainly conflicting testimony on that, means he wasn't willing to take it himself potentially. So we have to start with that. And if he's unwilling,
Except that you said that the state hadn't even asked him to take a polygraph.
Well, there was no testimony on
Well,
that. We don't
right.
know
We
if
don't
that
know
was
if
the
that's
case.
record. But with the testimony that came in, I understand that obviously juries is free to believe or disbelieve this, but evidently the testimony came in was they were playing an Xbox game and talking live, and he just said, yeah, you can help me by taking a polygraph, that's at least what he said.
Yes, and that was the testimony.
So there was nothing there that said anything about anyone offering him one.
No, and we don't know if it was offered. But that brings up other issues. Once you say the word polygraph in court, now it brings up a whole host of issues because it becomes the elephant in the room. Jurors want the guilt or innocence to be a gift wrap for them, or the credibility gift wrap for them if they can have it. And once we talk about polygraphs or quote lie detector tests, now we're bringing up in the minds of any reasonable person. Well, was he offered a polygraph? Did he take a polygraph? Was he willing to take a polygraph? What were the results? It then opens up the big can of worms that every one of these cases doesn't want us to open.
I'm sorry, the state cites the State versus Barton case and for the proposition that this is okay. Now, I know you tried to distinguish Barton, and in reading Barton, I think, from my reading of it, it may be a little bit different. In the respect that the court said that the defendant there had opened the door. So therefore, by opening the door about cooperating with the police and so forth, and saying he was cooperating and refused to take a polygraph, they said that that was going to come in. So I guess my question to you is this. Didn't he open the door himself in regard to contacting his half-brother, however it occurred, and talking about a polygraph and wanting him to take a polygraph?
I appreciate your question, and I asked myself that question actually. I think when we're talking about opening the door to admissible evidence, when we say opening the door, we're talking about what did the defendant do during the course of the trial that brought this issue up in the first place, that now the state has to address it. And that is what happened in Barton. I believe the testimony based upon the case, my reading of the case was that the defendant specifically testified that he was cooperative during the investigatory process, that he offered to take the polygraph, that he took the polygraph, and then the state came back on rebuttal and presented evidence from the polygraph examiner to state, wait, he wasn't that cooperative as he would like to present, because he was taking steps during the course of the exam to defeat the exam and to skew the results. I think it's very distinguishable because in this case, in this trial, Mr. Austin didn't present any evidence about polygraph. In fact, it was the state that sought out Mr. Caldwell, found him, and then put the defendant on notice the night before the trial that Mr. Caldwell's testimony would be presented at only and specifically for the purpose of presenting this testimony about a request to take a polygraph. That was the only testimony.
In mind, then, is the argument that there could be no limiting instructions specific enough to cover the admission of the word polygraph test into the...
Well, I don't know if there could be a limiting instruction specific to that, possibly.
Meaning, do you believe it can never be admitted for any purpose? Is that the argument?
I think this testimony could not have been permitted in this case for any purpose. Now, I know that the case law has said if there's a limiting instruction, i.e. you're not permitted to consider this fleeting reference to polygraph for a purpose of consciousness or guilt, or even of guilt. I know there's quite a bit of case law, I know that we cited some of it, that stated that just mentioning a polygraph exam is not in and of itself going to be dispositive of whether the trial is fair. And I refer specifically to State v. Roe. And I think when you talk about that limiting instruction, that was actually whether a curative instruction was requested. I think that was actually one of the first factor. In this case, the limiting instruction not only wasn't requested, but the trial judge specifically included an instruction that said that the jury could consider Mr. Caldwell's testimony as evidence of consciousness of guilt. And furthermore, then the prosecutor, of course, prior to jury instructions, commented in its closing arguments about it. So not only Could there have been no curative instruction in this case? It kind of was inflated throughout the course of the trial, right into jury deliberations through the instructions. It became, like I say, the proverbial elephant in the room. And in a case such as this, where the entire case, first of all, the allegations were extremely old. More than a decade had passed between the alleged offenses and then the trial. There was no physical evidence, there was no scientific evidence. The entire case was built on witness testimony. So in a case such as this, where the jury has to choose who's more credible and whose testimony is more to be believed, the defendant and his witnesses versus the state and the state's witnesses, having something like this, where we're talking about polygraph exams or lie detector tests, is absolutely unfairly prejudicial to the defendant.
Let me ask you this, since you bring up credibility issue, posit a scenario to you here. If you said your stance that it could have never, this information or this testimony could never have been introduced, hypothetically, if it was not introduced in the state's case in chief, but your client chose to testify, and I know you're arguing that perhaps he wouldn't have, we don't know that, could it be introduced in terms to challenge the credibility then? Rather than consciousness of guilt, what about credibility? I.e., from the state's position, you're a cheater, therefore a liar, and from his position, I was just being sarcastic. Would that make a difference to you?
I think in this case it would not. I think again, at least in the context of this case, once you start talking about polygraphs, it goes just beyond trying to establish that somebody's not being truthful. Now you're bringing up the whole scientific issue.
So if somebody, I'm sorry, go ahead and answer the question.
I actually finished. Go ahead, Ron.
So if somebody, I just thought of this, if somebody actually did get somebody to take a polygraph for them, it still couldn't come in? I mean, if the brother had actually gone down and taken the polygraph. Okay, and, we euphemistically call it passing your family, we know that's not true.
Right.
But could that have come in, and you're saying it couldn't have either?
Perhaps, well, now you're talking about evidence of a crime, and I think that may be different.
Well,
Because
isn't
now
that-
taking a polygraph for someone is now a crime committed by another person. It's obstruction.
And that's what I was actually gonna get at. Couldn't this be a crime anyway? Suborning perjury, obstructing? I mean, it could have been charged as a crime.
I don't think, I think in this case it was not admissible, because it didn't happen. And I think there was a substantial amount of, there was rebuttal evidence that was presented by Mr. Austin that that's not really what he was doing. And of course, he was forced to testify because of that, and waived his right to remain silent. I don't know if he would have chosen to testify anyway.
And
But-
counsel,
Yes,
I need to inform you that you've utilized your 15 minutes of time today. Thank you so much.
thank you very much. I'd just like to close by asking the court to vacate the convictions and remand for retrial. Thank you very much.
Thank you. For your presentation today, the court will take the matter under advisement. We will issue a written decision, which will be known to both sides, as well as posted on the Ohio Supreme Court website.
Thank you.